the rule of conflict is the rule like this. Okay, so very basic rules of conflict. In the first case, domestic law prevails over international law. In the second case, international law prevails over domestic law. Why do we need that, or some definition of this? Why do we need that in monist states? And this is absolutely useless in dualist states.
Because in a monist state, the international law automatically becomes domestic law. So we need this rule of conflict to ensure the application of both law.
Yeah. In domestic, let's say that this is the domestic legal order. Okay? Domestic legal. In a monist system, you have domestic law, of course, but you also have rules of international law. But we go within the domestic legal order. Okay, that's the. Okay, so. Okay, so the rules of international law will be applicable within the national legal order. Okay. In dualist states, rules of international law will never be applicable within the domestic legal order. The only thing that will be applicable is domestic law and domestic law of incorporation. Okay? So there are some rules of domestic law that incorporate rules of international law. But the rule of incorporation is a domestic law rule. It means that what you apply in the domestic legal order in a dualist state, it's always domestic law. It's not international law. Okay? But in monist states, you apply, or you may apply, rules of domestic law, of course, but also rules of international law. So, as you have at least two sets of rules, you have to identify which one prevails over the other one. But in dualist states, you only have rules of domestic law, so you don't need a conflict rule or a conflict provision regarding international law and domestic law, because all the rules that you apply in the domestic legal order are rules of domestic law. Okay? So, we can see some. So, is it okay for everyone, please? Okay, so in dualist states, you don't need rules of conflict between international law and domestic law, because every single rule that you apply in domestic legal order are rules of domestic law. So let's see some examples of that. Here we go. Yeah. So you need rules of conflict, and you need to determine what is the hierarchy of norms. So if we take the example of France, the constitution is at the top of the hierarchy. Then you have international treaties and statute law, say acts of parliament. If the conditions set up in Article 55 are met. Okay, so treaties prevail over acts of parliament if they are fully ratified upon publication and with respect of the reciprocity principle. Okay, so in France you have constitution, international treaties, statute law. That's the situation under the constitution of the Fifth Republic. Second example of monarchist states, the solution is the same for the Constitution of the US and for the Constitution of Germany. At the top is the Constitution, and then international treaties and statute law, means acts of parliament, have the same authority. So, if we say that the acts of parliament and the international treaties have the same authority in the domestic legal order of the US or of Germany, how do we implement this? How do we decide? If there is an act of parliament and a treaty that states two opposite solutions to a very same situation? How can we decide if the state has to rely on the international treaty or on the act of parliament? If we say that both have the same legal authority in the domestic legal order. Well, let's say, take the same example as previously. Okay, Mr. X, okay, right to retire at 60 if we apply the treaty, okay, and no retirement before 65, okay, if we apply domestic law. Okay, so here there is two provisions that you cannot apply together. You have to decide if Mr. X has the right to retire at 60, or if he has to work 5 more years before retirement. If you are in France, you have the answer in the Constitution. If the treaty has been duly ratified, etc., you will apply the treaty. In Germany and in the US, the constitutions only state that, the constitution prevails, but international treaties and statute law, acts of parliament, have the same authority. So how, let's say that here we are in Germany or in the US, how do I decide if, as a judge, as a German judge or as an American judge, how do I decide if Mr. X has the right to retire at 60 or has to work 5 more years? you think that the Constitution has a spirit on the age of retirement?
Yeah, you might check the date of promulgation.
Yeah, that's just a question of time. Well, if the treaty has been adopted on the, I don't know, the 1st of January 2000, and if the statute law has been adopted on the 1st of January of 2001, this one will remain. Okay? As they have the same legal authority, the new one will prevail over the older one. Okay? Third example, what can I give you? Okay. This one. Well, in the Turkish Constitution of 1980, you have this. The Constitution is at the top. Then you have human rights treaties. Then non-human rights international treaties and statute law, which have the same legal authority. Okay. So here you have you state that some types of treaties will prevail other types of treaties. The human rights treaties, the problem is how do we define a human rights treaty? So it may be a problem. Of course, the European Convention on Human Rights is a human rights treaty, but can we say that a treaty regarding environment could be seen as a human rights treaty or not? Well, this could be discussed. And after that, or below that, there are the international treaties that are not human rights treaties, and statute law means that this provision is similar to this provision is similar to this one. Okay, but there's just here between the Constitution and the international treaties a specific status recognized to the human rights treaties. Okay, so in monist states, you have to decide most of the time in the Constitution which act will prevail over the other one. You have to decide if international law prevail or international treaties prevail over domestic rules, the statute law. Well, in every state, the Constitution is at the top. There's no state that's recognized that above Constitution there is the rules of international law. So in most states, you have a rule of conflict between international law and domestic law. In dualist states, you don't need that. We will explain why. But first we can see. So dualist. So the United Kingdom is a dualist state. Italy is a dualist state. Japan is a dualist state, etc. Cambodia is monist, dualist. You know.
It's kind of mixed.
So explain.
Well, it must be Cambodia follow the dualist, but some other scholars say that Cambodia also follow monism as well, because based on the constitution of Cambodia, the treaty that's signed by the government must be ratified by the National Assembly and then ratified by the king.
Yeah.
So the process of ratification is in the same process as legislative, the rule of incorporation of law. So for any ratification of the treaty, it must go the same process as legislative.
Okay.
But one say that Cambodia also follow the monist because in one article in the constitution say that Cambodia recognize any international instrument related to human rights, women rights, and children rights. And according to the Constitutional Council decision in 2003, the body that have the power to interpret the constitution would say that when the judge make decision, they have to look into the international instrument that related to human rights and women rights and children rights, even if it's not go into the same process of ratification. But the constitution already recognizes it.
Okay, but Cambodia has to be party to that treaty.
Yeah, Cambodia has to be party to
But
the
how could Cambodia be a party to the treaty if the ratification process
some human rights treaty, Cambodia became the party to some human rights treaty before 1993.
Okay.
So it's prior to the adoption of constitution.
Oh, okay. Okay. Well, to me, this looks like a modest state. As I understood what you said, because, well, of course, the legislative body is involved in the ratification process, but it's, as far as I understand, it's only the ratification process. It's not an incorporation process. No, well, it means that the treaty does exist once ratified, does exist in the Cambodian system, in the Cambodian legal order, has a treaty and not as an act of parliament. No, I really don't know. As far as I understood. Well, just if you have a litigation before a Cambodian tribunal, can you, and if you want to rely on the provision of the treaty, will you rely on the provision of the treaty, or will you rely on the provision of an act of parliament incorporating the treaty into the domestic legal order?
I would say the judge look into the incorporation because whenever the treaty is signed by the government, the treaty is translated into Khmer and then adopted by the legislative body as the law on the ratification of that treaty.
Okay, but does the legislative body has the right to modify the law after this process?
Well, if it becomes Cambodian law, I think the legislative body has the right to modify the law. But I think it's the same as you mentioned earlier. The legislative body can modify as long as it's not violated.
Okay, well, okay. I don't know. I don't have the answer. So dualist states like United Kingdom, Japan, and Australia. And we can see to finish this. this case, Ministry of State for Immigration and Ethnic Affairs versus Theo. It's a 1999 decided case by the High Court of Australia. So, the case was a question of immigration or the question of deportation from Australia. And the court said that ratification of an international convention can be a basis for the existence of a legitimate expectation, and that in this instance there had been a want of procedural fairness. The majority agreed that there had been a breach of natural justice, as the Immigration Department has failed to invite Theo to make a submission on whether a deportation order should be made, contrary to the Convention on the Rights of the Child, which provided that in any administrative decision concerning the child's best interest must be a primary consideration. So, in that case, the problem was that the Convention on the Rights of the Child has not been incorporated into the domestic law of Australia. Okay, so Australia is a party to the treaty, to the Convention on the Rights of the Child, but the treaty has not been incorporated into the domestic legal order of Australia. Australia is a dualist state, so Theo, which was a minor for which the Australian administration tried to take decision of deportation to Malaysia, I think. The High Court of Australia was in a situation where the Convention on the Rights of the Child cannot be applicable because Australia is a dualist state and the Convention has not been incorporated into Australian legal order. But the court says that there is an obligation of fairness. There can be some legitimate expectations for the individuals when they see that the treaty has been ratified by the state. It means that the individuals may think that they can rely on that treaty even if the treaty has not been incorporated. So the High Court of Australia says in that case that even if the treaty has not been incorporated into Australian domestic system, into Australian domestic legal order, then, even though it has not been incorporated, the claimant, Theo, had some legitimate expectations regarding the implementation of the Convention, and then the High Court of Australia accepted that Theo, the claimant, can invoke the benefits of a convention that has not been incorporated into the domestic legal order. And this decision, of course, blurs the line between monism and dualism. Because if you recognize that Australia is a strict dualist state, has a strict dualist system, then you must say that as the convention has not been incorporated into domestic legal order, the convention cannot produce any legal effect in the domestic legal system of Australia. But, and maybe it's because it is this specific convention, the Australian High Court of Justice decided in favor of the claimant, stating that the Convention on the Rights of the Child even though it has not been incorporated, can produce some legal effects into the domestic legal system of Armenia. Okay? Yeah? Questions? So, see you tomorrow.